you're looking for, I think, especially just as practical takeaways for folks, I think you're looking for certain language. That other minerals word is really important in any kind of, whether it's a lease or whether it's
Conveyance document.
a conveyance. Yeah.
Yeah. So, I mean, I think East Texas, I think leases in general, we bought gobs and gobs of them over the last 20 years here in Texas or throughout my career. And, oil, gas and mineral lease, you see it pretty commonly, in a lease form. Um, 10 years ago, 15 years ago, landowners started to more and more often do hard minerals exclusions from their leases. The intent being, hey, this is just hydrocarbons. It's a hydrocarbon lease.
Right. Right.
Are there circumstances where, for instance, you have that traditional oil, gas, and other minerals lease that does not have a hard minerals exclusion? Is it safe to assume that potentially that could be those lithium rights from that produced water, since is that considered a hard mineral? So is it safe to assume that if they didn't exclude hard minerals from their lease, that you would need to work out a deal with the working interest owner of that lease?
Yeah. And I think I want to just to nuance it a little bit. When we're talking about oil and gas leases, it's not so much of an exclusion as much as it is a direct conveyance. So that's what we see in cases out of like the 70s and 80s in Texas, of like whether it's an express conveyance, like you have to so if your lease is oil and gas, my argument will be that does not include other minerals. So the landowner doesn't necessarily have to exclude those things out and hold those things back. They have to expressly convey them, the mineral interest owner does. If your oil and gas lease says oil, gas, and other minerals, I'm certainly going to argue that when you're conveying the other minerals, it's all other minerals, except for those that have been carved out. And so there are certain elements we said those still apply to the surface estate. Caliche, limestone, those elements, we've dealt with those.
Yeah.
The
That
big
could be the source of why we would see those exclusions, leasing a mineral owner that also owns the surface. That became, a thing that they were informed about. Potentially you had oil and gas development, oil and gas operative would try to, extract rock or caliche from land because they said they had the rights to it in their lease. So I think that's what we really started to see that start to show itself. But, as you start applying these new things, you're like, gosh, who owns these rights? How do I secure those on behalf of my client? I'm doing it.
Well, and
whatever.
And remember, in Texas, you've also got to deal with, if you're a surface owner and you just have the surface, you've got to deal with the accommodation doctrine. And so that, the mineral estate is that dominant estate. And so they have the right to use so much of the surface as is reasonably necessary to produce those minerals. But that's where we run into another issue with some of the legislation that's come out, because that right it's a usufruct right. It's not a conveyance and it's not ownership. We're not saying that oil company, that operator has the ownership of the water. They simply have the right to use the water. What this legislation has come in and done is they have said, because, and imagine this is the scenario I like to paint, is like you go drill a water well out there, you're the operator, you go drill the well and you're going to go inject and use it for fracking or for water flood or for whatever. You're allowed to do that. But you're allowed to use it. It doesn't mean you own it. You own it. And so some of the legislation comes in and goes, but once it comes out of the hole and it's produced oil and it's produced water and it's liquid oil and gas waste that's been defined, it's a transition and it's a conveyance within the legislature. It's like landowner didn't convey that. They didn't give a right. And so now we're looking at what would be a Fifth Amendment taking violation. And this violation on constitutional rights. If you've taken my rights and you've given them to someone, and you've taken something that belongs to me as the surface owner, and you have given it to this other person who hasn't paid for it.
And who gets, even if they did take it, who gets paid? If it, so if they have
Right.
monetized it by extracting lithium or whatever hard mineral might be, we may discover in the next 20 years that we can extract. Who gets paid
Right.
and what are the terms of that payment? Um, how do you access those rights? I think the takeaway is that we know it's an issue. We don't know the answer. Clearly.
Yeah.
Well, that's
I know
just awesome.
what's the legal answer always is it depends.
Yeah. Yeah.
What's the realistic timeline that you think this will be resolved? Like, how quick is it going to move or not going to move?
I mean, in terms of like timeline with the Supreme Court, I think this is something within the next 2 years.
Okay.
We see whether they're going to take it, and then we see whether it go. If they take it, then they're going to ask for briefing, and then you're probably looking at 24 months there. Now, the issue with the Supreme Court though is they're just going to look at, they're confined to the actual case.
Yeah.
And the way this
Yeah.
case got decided is because of the unique granting language in the lease. So they didn't discuss that. They discussed the House bills and they discussed the legislation that's out there, but that's not the basis of how they define their decision. And so, not saying that the Supreme Court wouldn't address it, but then you would have lawyers who will certainly argue that it's dicta, that it's not actually the issue in the case that's being decided there. It's just the Supreme, they might opine on how they think the legislation should be resolved, but doesn't actually impact it.
Do you think that another case would pop up in another part of Texas before the Supreme Court rules?
I think that's going to happen.
Okay.
The reality is what we're seeing is technology is advancing so quickly with our ability to treat this water. And they were doing tests with the cotton crops well over a decade ago, where they're saying like the treated produced water is able to be put into agricultural use for cotton, and you're getting similar cotton yield from it. And so in that kind of scenario where you're not having people, it's not being consumed by wildlife, it's not being, not potable water at that point. Why wouldn't we use it for those kind of purposes, especially as potable, and fresh water is diminishing.
Especially in the parts of Texas where there's not a massive water table. You're talking about desert conditions. Water is a valuable thing. And obviously that's why these companies like Cactus Water and all that are trying to seize opportunities to take advantage of all this water that's being produced and the market for it, things like that.
Well, and you're going to see it also in the sense that I think it is inevitable that there's going to be greater and greater legislative action requiring operators to use produced and recycled water in order to drill, frack, complete, and recomplete wells. I think that's coming as fresh water continues to diminish, and it is a necessary resource. I think the requirements on reuse of water are going to increase. And so the value of that produced water is going to increase. And the scenario I always like to paint for people is that we've talked about it in the sense that it's going to help preserve fresh water and preserve and prevent the usage of fresh water under, the accommodation doctrine and their ability to go get fresh water. I actually would argue that it's probably going to increase our freshwater usage as we get closer and closer to requirements to use more produced water. And the reason why is because of the legislation that we have, where it actually allows where before it's a right to use. Now they're saying if you inject it down hole and it comes back up, which we know it does as produced water, it becomes yours. And you can do with it as you want. So why wouldn't, as the requirement is going to be to use produced water, why wouldn't operators use as much fresh water as they can that then becomes their property and their right to use in the future?
That's deep, Bobby.
It's really deep.